Good evening, everyone. Good evening, good evening, good evening, everyone. This is attorney Nicole Huffman of the Law and Legacy Building Firm, or you may know me from Now with Nicole, or my ministry, The Worthy Project. And today I am here to discuss dying without a will in Texas, what couples should know when they have children who are not also the children of their spouse. And this could be a child that was born before the marriage, or can be a child that was born during the marriage. And in that case, you have other issues outside of estate planning, which I'm not going to address here, but it's for any child who's yours who is not also your spouse's. And when it comes to children who are born during the marriage, for instance, who are not your spouses, we then get into the issue of legitimacy because in Texas, because all this is based on Texas law, if you're just now tuning into this series, it's a part of the Family History Month. And I've been talking about estate planning and just giving different tips for certain subsets of people here in Texas. And this is not meant to be legal advice. I am not assuming an attorney-client relationship. And if you would like more information, please consult an attorney in your local jurisdiction, in your state, in your local jurisdiction. However, a lot of the things that I'm talking about, they should be considered by anyone in any area. Just generally, if you don't have any estate planning done and you're married and you have kids that aren't your spouses, you may want to speak with someone, a lawyer in your area, and talk to them about what could happen with your property once you pass away. So one of the things that we have in Texas is our illegitimate child, if you will, law. And if you have a child who, say for instance, the child was born during the marriage, or the child even could have been born before the marriage, and whether you knew the child was born or not. And what happens is that if you have a child that is not born during a a marriage, that child is considered to be illegitimate in Texas unless the parents later get married, or if the father has claimed the child on a birth certificate or on some kind of affidavit saying that he's claiming parental rights, or if a DNA test has determined that he is the father, and that could be a DNA test that led to child support during his life, or it could be a DNA test that was done after the father died. So those are the ways that you can prove legitimacy. Thus, if you have a child out there who was born not of your marriage, whether, like I said, it was during your marriage and your spouse knows or maybe doesn't know, or if it was before your marriage and your spouse knows or maybe doesn't know, or maybe you don't even know, there's the possibility that that child, if you don't have a will, if you don't have estate planning documents in place, that child that child will have to be considered is going to be considered in your will. I'm sorry, in your estate. If you when you go to probate in Texas, if you don't have a will, all of your children, whether they were born through the marriage or outside the marriage, they are all going to be considered when the court goes through the probate process. Furthermore, even if the child was not known during the time and there was a will, or if the child was known and the person was trying to disinherit them for whatever reason, there also there also is set up some protection. There's also set up some protection from children when there has not been proven, there's not proof during the father's life that this was their child, for instance. So if it's proven after the father's death, well, yes, this was his child. Well, the child, even if there was a will, if that child is not mentioned anywhere in that will, the child cannot be disinherited. So unless you have put something aside in some trust or some kind of life insurance or something, you can't just disinherit this child who, for all intents and purposes, was illegitimate while you were alive, because you never claimed the child. And so it was never known that this was your child. Therefore, after you die, whether if you die without a will, the child is going to be entitled to a part of your property. If you die with a will and you don't mention this child, you're not going to be able to, you can't just disinherit this child. So you would have to have had something in place in order to, in order for the court not to decide that you were trying to do something sneaky or underhanded, or you're trying to harm the child. In order for them not to still give the child some part of your estate, you need to have something in writing in place that acknowledges that child, if you know the child is there. But that's another issue that comes up, because if you don't even know that this is your child, and later the child's mother pops up during probate and says, well, this is his child, and a DNA test is performed, well, then there, even if you had a will, they're still going, the child is still going to be able to get something from your estate, because the child, because his or her identity was not known, or you didn't know they were your child, and so they can't be disinherited. And those are just some of the kind of complicated things that happen when you're dealing with a situation where you have children who are not your spouses. Because what happens in Texas, since it's a community property state, if you die without a will, your community property goes to, if you have children all by your spouse, all of your community property goes to your spouse. And then the separate property that you have, any separate personal property that you have, it's going to go 1/3 to your surviving spouse, and then the remaining 2/3 of the personal property is going to go to your children that you and your spouse have together. And if you have separate real property, and you don't have, and your real property, like your house, isn't also community property, then what happens is that your spouse would be entitled to 1/3, to an outright 1/3 right in the property, and then a life estate. And your children, they're going to be entitled to 2/3 of your separate real property. So here you have your community, any community property that you have, even community real property. If you and your spouse both have the same children, no outside children, the spouse will get everything in the community property. In the separate property, it's 1/3 to the spouse, 2/3 to the children. If it's personal property like cash, bank accounts, um, stocks and bonds, that kind of thing, that's considered personal. If it's that, well, 1/3 goes to your spouse, 2/3 to your children. If it's separate real property, like oil and gas rights or timber, a house, things like that. If it's real property, separate real property, meaning that you don't own it together in the community, it would go 1/3 to your spouse, and then 2/3 to your children. And if it's a house, the spouse gets a life estate, meaning that she or he gets to stay there as long as she or he is alive. Now, when you bring in children who are not in the marriage, well, then things change. And that's why it's important that you do estate planning because some people just assume that their property is going to go to their spouse, and that's not true. Even if it's community property, all of the property is not going to go to your spouse. What would happen if you have children outside of the marriage is that if you don't have a will, the spouse will retain his or her half of the community property, and then your half is going to go to your children. It's going to be split between them evenly. So if you have 3 children, 2 of them from the marriage, 1 of them is not from the marriage, all 3 of them will split everything evenly. All of your real property. I'm sorry, all of your community property. They would split your half of the community property equally. Then when you get to personal property, and if it's separate, it's separate personal property. What ends up happening with separate personal property is that the spouse gets 1/3, and the children, again, they get 2/3, and they all split that equally. And if it's separate real property, again, the spouse will get 1/3 and a 1/3 right in the property, as well as the right to live there as long as she or he, a life estate, as long as she or he wants to live there. They would get that, and then the children, they would get the remaining 2/3. They would have the outright rights to the remaining 2/3. So what ends up happening if you don't have a will is that your property may be divided in a way that you did not want it to be divided. You may have wanted your spouse to have everything. You may have wanted your spouse to have nothing but the community property. Those are some possibilities. Well, that's why it's important that you have some kind of plan in place, and just dying without a will and hoping things just turn out okay is not a good plan. And especially when you're talking about blended family issues, such as you have children who aren't your spouses. And then to further complicate it, as I was saying earlier, when you have illegitimate children and how the law is set up to protect them just in case you forgot they were there or something, or you just didn't know. The law is still there to protect that child from being fully disinherited when for instance, you may not have known they were there, or if you knew they were there but you didn't acknowledge them or anything in any will or in any other kind of document. The law is there to protect that child. So those are all things that you need to think about when you're married and you have children, and your children aren't your spouses. And another thing that comes up is in the step family situation. And according to the Texas Probate Code, stepchildren do not inherit from their step parents. Step parents do not inherit from stepchildren unless there's been some adoption that was granted. And if there hasn't been some adoption, or if there hasn't been some kind of proof that an adoption was on the table in the works or something like that, so that you can get there's a special exception when the adoption hasn't been finally legalized, but there were some steps taken, and it was going towards being legalized. And if you have that kind of situation where it wasn't the formal adoption, but they were going that way, well, in that case, that child or can inherit from that parent. So remember, when it comes to the step children thing, they're not entitled to the property. And if you want your stepchildren to have any of your property, it's important that you accommodate them in a will or in a trust or in some insurance or something. Because if you don't, they're not going to be able to inherit anything from you. And so if that's something that you want for them to be able to do, you should make sure that you provide for that. in the proper estate planning documents. And that's whether it's a will or a trust, insurance, however you decide you want to provide for them. You need to make sure that you put that down somewhere in writing, because if you don't, they're not entitled to inherit anything from you. So that's basically when it comes to being married and having children who are not your spouses. And again, that could be children who were born before the marriage or children who were born during the marriage. And I know a lot of times people, they, one of the reasons they want to avoid probate and do insurance or trust, things like that, is because they have a family situation that they don't want to get public. They don't want to become public, and wills are public. That's a public record, and they will provide for outside children, before children, or during children, outside of the will, so that it won't be any kind of public scrutiny of it. And that decision is up to you. That's fine if that's what you choose to do, but trying to just disinherit the child and not mention them at all, not acknowledge them, that's not going to work. So that's estate planning, just basic tips that I would give to anyone who's in a blended type of family situation. If you want any more information about this, you can always contact me at miriamnicolehuffman.com. You can also reach me on Facebook or Twitter at Now with Nicole. And you can find the other parts of this series on my website. This, and in the other parts, I've talked about why single people need wills, and why all people who have children need a will. So those are just some of the other topics I've discussed. If you know anyone who needs information about that, you can direct them to my website, miriamnicolehuffman.com. So I thank you all for listening tonight. And if you're in the Texas, Houston area, I invite you to join me for Women, Wills, and Wine, Ladies Night In, the estate planning edition, where I will be discussing different estate planning things that you should think about as you are wanting to build and leave behind a legacy for your children. And you can also find out that information on my website, miriamnicolehuffman.com. I hope you all learned something, took something from this, and you act on it. Thank you all for listening, and have a fantastic night.